Hello, so I'm Hannah Hill. This is Jon Hummel. We are with the National Foundation for Gun Rights. That is the National Association for Gun Rights Legal Arm. So we handle the legal programs. We coordinate the lawsuits against gun grabbers we have going in various states. And we also have a gun owners defense fund. So if you're interested in learning more about what we do, our website is gunrightsfoundation.org, where you can find out the latest on our programs, our lawsuits, and you can also donate to be part of the fight. So John and I wanted to come to you today to tell you a little bit more about the Supreme Court's landmark ruling, New York State Rifle and Pistol Association versus Bruen, and what that means for the Second Amendment. So this was the Supreme Court's first major Second Amendment case in over 10 years.
Yep.
So this is a big moment for gun owners. This has been something we've been waiting for years. Our foundation had actually filed an amicus brief in this case, arguing that the Second Amendment is not a second-class right, and that it is time for the Supreme Court to force the lower courts to actually follow the text of the Constitution and protect the right to keep and bear arms. And we are thrilled to say that in that ruling, they did just that. So they gave us just about everything that we asked for in our amicus brief, and we could not have done that without the help of the Foundation's donors. So thank you so much for being part of the fight and for your help in making this day possible.
Mm-hmm. Yeah, this was a huge, huge ruling, and now we get to talk about just what it did and why it's important for not just you, but the nation as a whole.
Right. So first, we should probably share a little background. So this was a challenge to New York's May issue permit law. So in New York, before this ruling, you essentially could not get a permit to carry guns. You couldn't open carry with or without a permit. I hope that's true. Let me say that again. In New York, you could not carry a gun in public without a permit, and you could not get a permit unless you proved to a local official that you had a special need to carry one.
Mm-hmm. And self-defense was not considered a special need.
It had to be something special, something above and beyond just ordinarily wanting to defend yourself when you're out and about. Mm-hmm. And not only that, but you had to prove that to the satisfaction of the local official you're standing in front of. So it was very discretionary, it was very arbitrary. Mm-hmm. And the way it worked, in New York, you typically couldn't exercise your right to bear arms.
Unless you had some kind of connection, had a lot of power, a lot of money. There were a lot of cases of bribery and things like that would come out because of this. So unless you were well connected or had some power, you were not going to be allowed to exercise your Second Amendment rights.
That's right. So that case, a challenge to that rule, went before the Supreme Court, and the Supreme Court agreed to take it and consider the question of whether or not the Second Amendment protects the right to bear arms in public for ordinary self-defense purposes. Mm-hmm. And that may sound like a duh thing to most of our members. I know it did to us, because that is what the Second Amendment says. That is what it protects. But the lower courts have been in the habit for years of dodging the text with what they call the two-part framework. This is how they look at and evaluate gun cases that come before them. And the first step of that two-part framework is they say, does this involve the Second Amendment? Does it involve what the Second Amendment protects? And of course, the answer is always going to be yes.
If it's a gun law, it implicates the Second Amendment. Seems pretty obvious.
And the second part of that test was a cost-benefit analysis. So if we uphold the Second Amendment, are we going to be comfortable with the number of guns that there are on the streets, or with how easy it is for you to carry them?
And the answer was almost always no. A perfect example of this is in the Ninth Circuit, where 50 out of 50 cases that came before that circuit ruled against gun laws. So this wasn't a balancing system, which is what they claimed it was. This was just their way to get around the Second Amendment and get around what Heller and McDonald had ruled and still be able to say no to the Second Amendment.
Right. And that's why it was such a huge thing when the Supreme Court said, okay, you can't do that anymore. Not only is New York's May issue permit scheme completely unconstitutional, and not only does the Second Amendment protect the right to bear arms regardless of what state you live in, now we're going to talk about this balancing test. From now on, if you're looking at a gun law, you have to start with the text of the Second Amendment, and then you have to look at the history and tradition. In other words, what did it mean to the framers of the Second Amendment and the 14th Amendment? when they passed those amendments into law. What is the history of this? If essentially it wouldn't have flown back then, it doesn't fly today. So here is the new test, the new analysis framework that lower courts have to use for gun cases. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. So in other words, the default is if it's about the Second Amendment, the right is protected. It goes on to say, the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So that's going to be a very hard thing to prove for most gun laws. Like there's for red flag laws, which Congress just passed funding to incentivize states to enact red flag laws all over the country. And maybe give us a little explanation of what a red flag law is while we're on it.
So the way a red flag law works is that a person can basically bring it to a judge. It might be an ex-girlfriend, a neighbor, could be a police officer, anyone like that, and say, you know, that Hannah Hill, she's a dangerous character. She is a threat to either herself or to someone else, and I know that she has firearms. And so what happens is that that person would go and report to a judge and say that they believe that Hannah is a danger to herself or others, and then the judge, without Hannah present or even knowing that this is happening, it's completely ex parte is the word they use, she's not there, they make a decision to say, okay, yeah, we are going to red flag Hannah and send officers to her house, and we're going to take her guns, ammunition, firearm accessories, all those sorts of things, her concealed carry permit, if she has one, all of that stuff. We are going to take that away without due process, without Hannah being able to defend herself at all, and we're going to just take it from her. And then at a later date, she can come and try to defend herself and get those back. But as we all know, at a later date, okay, that's sometime in the future, but she is being denied her rights until that date comes. And even when that date comes, we don't know how this process will work because it's not the same as a normal court proceeding.
Right. So you're losing your gun rights when you haven't committed a crime and you've got no due process rights in the process. So this sort of arrangement would have been completely unheard of in the time of the founders. It was completely antithetical to the Second Amendment, and it will be very hard to defend those in court. However, of course, we know the anti-gun left is going to continue to do that. This isn't a slam dunk. This ruling just gives us the tools to fight back better than we ever have before. So there's the ruling. This is awesome, so I wanted to share this too. The ruling concludes with this. The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to a government official some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense.
Yep.
So there was cheering in the office when this ruling came out because this is exactly what we wanted. This was exactly what we asked for in our amicus brief. And this is going to give us all kinds of tools to fight back against bad gun laws, including some that are actually before the Supreme Court right now.
Yes, so two that we just kind of wanted to highlight. One that's pretty important, it's a California one. It's Duncan v. Bonta. And this one has to do with standard issue magazine ban. So right now in California, they have it so that a magazine of this size, which holds 12 rounds of ammunition, would be considered a large capacity magazine.
And this is standard. This comes standard with most weapons.
This firearm, this is the magazine that you use in the firearm. And so they want to ban this in order to, for the balancing purposes, to protect the interests of the state. So as we look at this ruling that says no, you just have to look at what the Constitution says, what the tradition and the laws around when it was implemented, what they say. We're very hopeful that there's no way that this will be able
It's
to fly.
going to be very difficult to make any kind of case from the Founding Fathers that they should ban this.
Yep. Another one that's happening, or that is before the Supreme Court, that we're waiting to see what they do. The likelihood in all these cases that are sitting in front of the Supreme Court is what they'll say is, okay, look at what we just said in Bruen. All right, now make the decision based on that.
Now go back and try again.
Now figure it out. So the other one is Bianchi versus Frosch, which that would be a so-called assault weapons ban. So that's one that is pretty popular. That would be something banned under this. That's in Maryland where this law is in effect. So again, this is the sort of thing that if you look at the text and tradition, when the Second Amendment was ratified, you're going to see that, wow, these guns are pretty standard, and they're what people use to defend themselves, defend their homes, their properties, all that stuff. And that is exactly what the Founding Fathers would say, yes, the common guns of the time are what people should be allowed to use. So something like this is going to be, again,
very difficult to prove that the founders wouldn't have been okay with it.
Yes, so we have a lot of reason to be hopeful and excited for what's coming up.
Now, of course, we all know that they're not going to give up that easily, and California, in fact, is already trying to get around the ruling. So California's was also a May issue state. California's permitting law said you had to not only prove special need, but you also had to be of good moral character in order to get a permit to bear arms. So the Supreme Court specifically said that the special need portion of that is unconstitutional. They did not specifically address the good moral character portion. So California is like, let's talk about all the ways good moral character can be used to block your gun rights. So we can go on your social media and we can look at if you have any racist or hate speech there. We can say if you're not financially stable, whatever that means.
The financially stable one seems terrible. That is basically making a law that says if you're not rich
enough.
Yeah, if you're not rich enough, exactly, you don't get a gun.
And again, all this is up to the local officials that are enforcing it, how far they want to go. If they want to interview your neighbors and friends and get character references and everything else. That is exactly the kind of discretionary scheme that this ruling was very clear that they did not want, and is antithetical, again, to the Constitution. So we actually sent California a cease and desist letter warning them that what they're proposing, what they're encouraging their local officials to do is not only a violation of the Second Amendment, not only a violation of what the Supreme Court said in Bruen, but also a violation of the First Amendment and protected speech. So if you hear of anything like that happening, if any sheriff or any local official blocks someone's gun permit issuance based on that sort of thing, let us know. There's a link to tell us that on our website, gunrightsfoundation.org. We would be very interested in finding out. So hopefully that won't be the case. Hopefully they will think better of it after reading the legal warning or letters our lawyer sent them. But if they don't, let us know. We would be, again, very interested to hear it. I also want to just say in closing, this gives us a lot of ammunition to fight back against all kinds of not just unconstitutional rulings from the lower courts, but also unconstitutional state regulations. So right now we are very excited about all the possibilities. We're looking very carefully at the different possible challenges we could bring, the challenges that there are already going forward, and how we might be able to be of assistance. But we need your help to do it. So if you would like to chip in to our litigation war chest and help us go on offense against 10 years of bad gun laws, 10 years of bad gun rulings that we now have the opportunity to see overturned, go to our website, gunrightsfoundation.org, and make a donation. Yep. And you can also sign up to be on our mailing list there as well. And we will be sure and keep you posted about what we're doing going forward. So once again, thank you so much for your support, and have a great day.
Take care.